And then I will take the roll. Fleischman?
Here.
Shining? Shining?
Yep, here, just coming online.
Okay. Spyro?
Here.
You?
Here, thank you.
Great, thanks.
Okay, so because we do have a number of speakers today, we have 4, I believe, 2 of whom have time constraints. I'd like to start off with our panel, our presenters, and then move to public comment. And then after that, start off our discussion by having a little bit of conversation about communication norms and expectations as a group around that. But I'm going to start off with DeCarol. Thank you for coming back. I know you only have a couple of minutes. We did send you and all of the panelists a couple of questions that subcommittee members had subsequent to the last meeting. So wherever you care to begin, please go ahead.
Oh, sure, yeah. So with regard to negotiations, I did not envision that paraprofessionals...
DeCarol, sorry, it's difficult to hear you. Maybe try speaking again. Unmute yourself.
Check 1, check 2.
Yeah, I don't know, is it just me or is it?
No, the sound is
I
really
get
distorted.
a lot of feedback. Yeah.
It's too loud.
I have not done anything.
Much better.
Oh, that's better.
That's better.
Okay. Don't move.
Okay, I'm just going to stay right here.
Okay, thank you.
So, with regard to negotiations, I did not envision paraprofessionals would be doing direct negotiations pre-litigation. My specialty is direct services. I think with regard to access to justice, the question in my mind is not so much who has the information, but more so whether workers and employers know that the laws exist and how to obtain help gathering the information. I think there are very real concerns. Someone was talking about runners and stuff. I guess my follow-up would be, how are we distinguishing between the enforcement mechanisms for fraud claims brought against paraprofessionals and those brought against attorneys? Just in terms of what licensing procedures you guys are proposing and why those would be more relaxed for paraprofessionals, if at all. I also think more discussion when I leave, someone needs to discuss the price of law school because the real access to justice issues I'm not seeing in the conversation. And I don't think there's a direct correlation between paralegals not paying for law school and being cheaper, quote, cheaper, and those services being more affordable. That's not a given. So I know those were some of the questions that were asked. I think those are like my limits on it from a direct services standpoint. I want to actually tag team Dana because Dana, like me, she actually works for BetZedek, which is the only non-LSC funded program in Los Angeles. And so that's a very big deal in direct services because we're the few that can represent undocumented workers. And that's a huge access to justice issue. So Dana, you want to speak to that a little bit?
Sure, and DeCarol, thank you so much. So I'm Dana Hadel. I'm directing attorney for the Employment Rights Project at BetZedek in Los Angeles. And as DeCarol said, we are the only non-LSE workers' rights project in LA. I currently supervise 4 advocates, 1 paralegal, and 2 attorneys, and a litigation secretary, which means that there are 5 of us currently providing workers' rights advocacy for all 1 million plus undocumented immigrants in Los Angeles. And so the justice gap for us at BetZedek, and I know at Legal Aid at Work, is a very real thing that we deal with on a constant basis. And you know, I know DeCarol shares some of the concerns that I have with not only closing the gap, but asking the right questions in order to be able to close that gap, engaging in the conversations, and also not just making justice accessible to our communities, but making law school accessible to people, or the paralegal programs accessible, and you know, which is, I think, will really do so much in order to close that gap. But is this the right path for us to go down in order to close that gap? Are there other mechanisms that we can explore, other incentives, such as you know, possibly, you know, making a third year of law school a practicum for those people that are going right into legal aid, so that folks can work in their third year instead of incurring further debt. Is there an opportunity to you know, to shorten the paralegal process program in order for for people to be practicing? And I see that we have a question. So do we need to turn people away? That's a great question. Thank you so much. So I know that legal aid, like Bates Sedek, engages in a significant amount of advice and counsel. And so we provide advice and counsel basically to anybody that calls into our hotline. And so we are not turning folks away for advice and counsel. For representation, we are, but we're not turning them away based on income, or when we do, it's not a common thing. We're mostly turning folks away because we need them to represent themselves, because we don't have the resources in order to be able to represent them. Which brings me to another concern that I have, which is the diverting of financial resources, or lots of organizations vying for the same financial resources in a relatively tight you know, financial landscape, so that if there are organizations that don't regularly engage in the provision of legal services, if suddenly they have paraprofessionals on staff and they're able to then you know, provide these very limited services, will they be applying for the same private grants that Bates Sedek and Legal Aid at Work are applying for? But it is the work that we engage in on a regular basis, where we have experienced attorneys who can supervise the provision of these legal services, whereas other organizations may not have attorneys, experienced employment attorneys on staff that can supervise the work that's being done. And so there's a possibility of fostering an ecosystem where we're all, you know, trying to get at the same money, which is a really limited pot of funds, which I think is a given, considering how few people we have doing this work.
Dana and I are actually about to go run clinics right now. That'll probably go until 11. But
yeah, and I wanted, before you both have to take off, and thank you for DeCarol for introducing Dana, our other time-limited presenter. Yeah. I just a bit of sort of in response to your question, DeCarol, and just to correctly frame where we are. With respect to how paraprofessionals will be licensed and regulated, that will be the subject of many, many meetings, I imagine, of the working group. This group, of which you're speaking to a subcommittee of the full working group at this time, is charged with coming up with the licensing and regulatory scheme. So any assumption that they're going to be regulated in a manner that is less than lawyers, I don't think there's a basis for that assumption. And it is the people around this proverbial table that will be coming up with the regulatory structure. So that's number one. Number two, the state bar has considered the establishment of a licensed paraprofessional program actually for 30 years. It is just earlier this year that the Board of Trustees voted to establish a paraprofessional program. And the working group in its entirety, this particular subcommittee is focusing on a particular area, but the working group is not tasked with the question of whether or not we should have a paraprofessional program, but instead what the parameters of that program should be. So I want to be—
Leah, I'm sorry. This is Carolyn Shining. And I think we have limited amount of time with these two individuals. And I appreciate your position on that, but I'm not sure everything that you just said is accurate. And I have a couple of really important questions to ask them. Could I go ahead and ask some questions?
Absolutely, but we'll post the charge of the working group also, so everybody can see.
Yeah, I've read it. I've read it several times. So,
okay.
And I've read the State Bar Trustee minutes, and I've attended some of those groups. So, Ms. Davis and Ms. Hattel, if paraprofessionals—
I object to this. I don't think it's right for people to be cutting in and taking over. Leah hadn't finished what she had to say, and maybe some of us want to ask some questions, and maybe it should be raise your hand.
It's okay. Carolyn did indicate that she had a question. I've concluded. I've made my point. Hopefully, Linda or Araya can find the charge, and we can link to it in the chat box, because I do think I am accurate in what I'm saying. But go ahead, Carolyn.
Okay, and I hope someone is saving all those chats too. Okay, so Ms. Davis and Ms. Hattel, if a paraprofessional was regulated less than an attorney, would that be a problem for you in the employment space, specifically reasonable discrimination?
Yes.
Workplace grievances?
Yes. Yes.
Yes.
Between DeCarol and myself, I think that we probably speak with at least 100 workers a week. And I think of those 100 workers, maybe 10 present with straightforward single issue problems. So that what we're doing when we're supervising our paralegals and our volunteers in our clinics is we're doing an enormous amount of issue spotting, because, not only are there reasonable accommodation issues, but there could be wage issues. There are Cal OSHA issues, health and safety issues. There's the potential for retaliation. The universe extends so far beyond the small issue of, let's say, engaging in the interactive process, and seeking reasonable accommodations, that I, for one, have an enormous amount of concern over the narrowing of that scope, when in practice, the scope isn't narrow at all.
I have some more questions, but I'll defer to other members of the panel who have some too, and just hold mine till the end if we have time.
I don't.
Carolyn, I yield my time to you.
Okay. Could you, again, both of you, do you work with immigrant populations, and do those require special knowledge of federal issues and immigration issues that go on top of their employment issues? And if so, could you be specific as to the statutes?
Yes, many. Unions, we haven't talked about unions actually, in terms of, you guys brought up the grievance process, and I do think it's important that when you guys are having your discussions to talk about declining union membership, but IRCA, right? we're looking at those types of things, H-2A visas, the restrictions on those, sponsorship, discrimination, how we engage DOL's wage hour division, things like that. Things that you are able to train students to look at. But again, when you're looking at licensing standards, I would ask that you guys look at training, exposure, and experience. I think those are very key when you're looking at employment issues. It's very practicum driven. You hear a lot. You know what I'm saying?
Mm-hmm.
And I'll just add to that prior to the pandemic, about 90% of our clients were monolingual Spanish speakers without status, who are victims of wage theft. And
Go ahead.
Yeah.
I didn't mean to, go ahead.
no, it's all right. So we deal a lot with, we deal so much with the immigrant communities and with the consequences of asserting workplace rights. And we regularly have clients who are deported for asking for their wages. And it's being able to advise clients on what the potential fallout from vindicating their rights is an incredibly important part of the work that we do. And DeCarol, it looks like you have something to add.
Deanna, I just also want to say one thing that's important is Spanish and language competency. One thing that we see less of, at least in my experience, is lawyers speaking less other languages than English, like Spanish, Tagalog, Cantonese, these things. So we do rely on paraprofessionals, legal assistants, and things like that. So that should also be considered when you're looking at like why the stratification, who goes for what licensing, the self-selection bias of why I want to be an attorney. Those things should be considered too, I would think.
Okay, does any other member of the subcommittee, Ira? We can't hear you, Ira, or at least I can't.
Is there some other way I should do that besides do this?
You can raise your hand. You can raise your hand in the Zoom.
Oh,
I'm trying to stay on top of it all over here. So go ahead.
DeCarol, I'll ask both of you, but DeCarol, you referred me, and that was good catch, to that ethics opinion from the San Diego Bar Association, and it made some points about what a lawyer has to do in supervising non-lawyers in their office. So in order for the non-lawyer to give advice, the lawyer's got to be right there with the non-lawyer.
Well, the term of art is present. It's presence. So there have been obviously many decisions on what presence means in terms of direct supervision. I am not an ethics professor, but I remember hearing something about it.
All right. I don't know of any decisions on it, but maybe there are. But my question is this. When paralegals or whatever they are, non-lawyers in your, and clerks and students in your groups, both of you, give advice to clients, potential clients, whatever, callers, whatever they are you always present? And if so, what does that mean? I mean, is a lawyer always present? And if so, what does that mean? Are they in the room on the phone, or are they just down the hall in the office?
Yeah, we are present for consultations. Yeah, when we're doing like so virtual world, which we're in now, it means in the Zoom or on the phone with the student. While they're advising the client, they're on the phone with the client. They have to, in that call, consult with us, go through all the legal issues, go back to the client. It's actually, this is virtual world now. Go back to the client. If they have additional questions, they have to come back to us. It's a back and forth until we've addressed all of the issues. When we were in brick and mortar locations, we're in the office. We're there in a basement of some place, taking in clients and talking with the students while we're there. I'm not sure what else you mean by present.
I mean, are you sitting, do you hear the advice as it's being given or not?
No, we're not sitting there with the client and the student in the room.
No. Okay. How about Dana?
We are, when we were in brick and mortar, and I'm happy that we're not in a basement. I'm sorry you are, DeCarol.
No, I shouldn't. I'm just.
We actually are in the room with them when we're in brick and mortar. The virtual clinic, because of the honestly, because of the number of workers that with whom we speak on a weekly basis, we are not able to be in every place at once. What we do though, as we follow the same exact model as Legal Aid at Work. We have our volunteers. Oh,
I was going to say, I think we need to really distinguish what you mean, Ira, by in the room. Like, one, there are confidentiality issues, so we can't have clients hearing one another. And we do go from room to room, and we do have direct client contact. The client always has access to the attorney as well.
Yes.
So I
didn't say, well, you're asking me what I mean by in the room. I mean that a lawyer is hearing well, you've answered this, DeCarol. A lawyer, when a non-lawyer gives advice to somebody, a lawyer is hearing it at the same time and can step in and correct it if needed.
When in the virtual world in which we live, we are providing the way that our model goes is that we have very specific questionnaires, very specific checklists, which we've prepared for all of the volunteers. And they go through all of these checklists and they take notes, basically verbatim notes of what the client is answering. And then these documents are uploaded in order for us to see basically like the verbatim responses which the attorneys review with the volunteers in order to then be able to provide the advice and counsel. Where there are complicated legal issues, we have either the attorney get on the line with the client, or we schedule follow-ups for the attorneys to do full intakes where, like, for instance, we encounter pregnancy discrimination matters, which are far more complex, sexual harassment, where we have complicated wage and hour intakes that we have to do. And so, but, where we have the straightforward issues, we're able to see, and after the checklist has been gone through, we're able to see what the responses are and then be able to tailor the advice specifically to what the issues are. Our volunteers are trusted. We rely on them. They're repeat customers, so to speak. And they then convey this advice and counsel right back verbatim to the clients.
Well, you probably can see what I'm getting at, but it was suggested by the ethics opinion DeCarol referred me to. Do you think it would help in advising all the large numbers of people who you do advise to have paraprofessionals licensed, but only to work under the supervision of an attorney and licensed with the same ethics and disciplinary rules and programs that apply to lawyers? Do you think it would help your programs so that there would be no issue of your violating this ethics principle by not hearing the advice as it's being given? It wouldn't be required if they were paraprofessionals.
I believe the ethics opinion that you're referring to, Ira, is the 1983 Tech 7, right? And they distinguish between general supervision and direct supervision, and direct with the presence is in court appearances.
No, that's not right. It's any advice. I read it.
Okay, either way. Are you asking if we replace a student with a paraprofessional, if that would be easier?
No, I'm asking if you replace any, not even replace, if the people who are working for you in your program now, who are not lawyers, if they became licensed paraprofessionals, the same people or additional ones if you want, and that loosened this, that made inapplicable this San Diego opinion that we're talking about. That's what it is, DeCarol. Would it, and they're subject to the same ethics rules, the same discipline. Would that make it easier to service these large numbers of people that you're servicing?
I don't want to speak for you, DeCarol, but I will tell you that for us at Beit Tzedek, no, it wouldn't help. I still would want every single case to come to our panel of attorneys to discuss.
I'm not asking.
So, and I need to really read the opinion because this is important. Activities requiring direct supervision by attorney according to the same rules include giving counseling and legal advice to clients, appearing on behalf of the client in any public trial, hearing or procedure, or excuse me, hearing or proceeding, or any public agency, referee, commissioner, or hearing officer to the extent approved by that body. Like, I just need to be
reading part of it. You're only reading part of it.
I'm gonna just jump in because I know Gigi made a comment, are we off on a tangent? One of the things that would have to be done with the establishment of a paraprofessional program is modification of the rules of professional conduct and applicable statutes. So I don't think we should be sort of focused on a current ethics opinion out of any particular jurisdiction. I think your broad question, Ira, was, would these legal services organizations find it helpful? We heard from Dana, no, because she would still want to have everything go before an attorney. I'm not sure what your response is, DeCarol. Just to the general question of would it be helpful?
I have to give a quick, I'm going to hang up, but I do think it would be beneficial in terms of having people already trained. We do have to train the students year to year. We train each of these students. If you have continuity of service, right? If you have a paraprofessional that's been doing this year after year after year after year, and not in a clinical situation, they're going to gain a better understanding of the direct services. And that specifically, you know, knowing the statute of limitations, knowing what administrative exhaustion is, knowing what agency access is. You know, I hope that makes sense. But Hannah is absolutely right that we're still going to want an attorney to be supervising, because these issues are complex and could give rise to any number of employment issues that are related.
I agree. It's just that they wouldn't, just like now, they wouldn't have to be there immediately hearing the advice as it's being given. I think, I'm certain that's what the San Diego opinion says.
Okay. All right, so we thank you, DeCarol. I know you have to jump off. I appreciate your participation. We have a couple more speakers. I just want to make sure, and members of the subcommittee, just interrupt me if this would not be valuable to you. But our focus today, you'd winnow down employment, the remaining issue, workplace accommodations, workplace grievances. I think we were challenged in really articulating the tasks or the activities within those topics at our last meeting. And I feel like, at least from a staff perspective, it would be helpful just what the steps are when you're trying to carve out what might be appropriate for a paraprofessional to do, what would not be appropriate for a paraprofessional to do. If the rest of the subcommittee feels like you do have that understanding, then ignore my comments. But I know in our email to the panelists, we did ask you to take us through a little bit procedurally how these different case types go. So I would ask, we've got two left. I think Eric is the one I have up next. I'm sorry, I'm losing my paper with your last name, Schweitman. If that's something you could do as part of your remarks, I think it would be beneficial. And Eric, you're up next.
All right, how you doing? Thanks for having me. I'm a little behind on the whole process here, so I was trying to get up to speed as quickly as I could on your sort of focused question. What a workplace grievance would be could be almost anything depending on the context of your employer, what they're doing, where they're doing it, how they're doing it. So you have union versus non-union shops, you have ordinary at-will employment, you have different rules for different cities in some instances. But in the general sense, you would look at it from an employee has a problem and they go to HR or they need somebody to help them navigate what it is. And the number of things it could be are, there's incredibly varied. So, when you look at it, I guess the best way I would look at it is if the employee has a problem and the employer is trying to do the right thing and solve that problem or not, there's a process that they have internally. And that process has to follow the legal ramifications and the legal guidelines of whatever the city, state, and federal law is and the regulations that go with it. So it could be something as simple as I wanted a day off and I couldn't get it. It could be something as complicated as I'm injured, I have a doctor's note, I need accommodation, I need restricted duty, light duty, whatever. It could be I was disciplined and I don't agree with it. It could be my coworker is bothering me and nobody's doing anything about it. And, it could be protected activity. It could not be. It could be minor. It could be illegal. It could be not. It's really hard to say, and where you're trying to draw a line in order some bright line to say the paraprofessional can do 1 through 4, but not the rest seems really challenging. I think it's something where there are certain instances where I think that would be very helpful to have somebody to be there to support them. And I think in other instances, it would be very detrimental for both the employer and the employee to have somebody who's not fully versed in these very, very complicated issues. There are certainly some things that just having somebody, even not a paraprofessional there, just for support and to provide some guidance would work. But it's very, if you took a union example, you have a collective bargaining agreement, you have federal labor law, you have steps in the agreement, you have step 1, you have step 2, you end up in arbitration, you have precedents, you have side deals, you have all these things that I think would be very, very harmful to the employee to not have a truly trained expert opinion on. On the other hand, if I need to leave 15 minutes early because my kid has to get picked up from school, then that should be something that they should be able to handle. And it really just depends on, I think, the nature of the issue. And I think you get very, very, I think more often than not, having somebody with limited training or a base training would be very detrimental to the employee's best interests on that particular issue.
Thanks. That was very helpful, and thank you so much for being here. Can you give us an example? I mean, you did with the I need to leave 15 minutes early to pick up my child, but is there more of a systemic example that we could use to understand where such a person would be helpful and not detrimental in a systemic way, as opposed to like an incremental example?
Yeah, sure. So systemically, well, I suppose you could, I guess there are certain things you could say. So I'm a management side employment lawyer, done for the last 20 years. So I am on the side of advising the employer. So looking at it from the employer's perspective, I wouldn't want anybody else involved in this process at all, because that's just a general matter. I don't want anybody else there. I don't want disinterested third parties or interested third parties there. We don't usually want to have lawyers involved in day-to-day affairs. So if you were to say, okay, let's find a way to make that helpful to the employee, I think you could look at it from maybe, basic requests for time off or accommodation, not involving complex medical issues, low-level discipline maybe, or initial disciplinary matters, first warnings, oral warnings maybe, schedule type of things that don't involve any kind of complicated issues. I think that if you looked at it from a day-to-day perspective, I don't know how you would define it, minimal, minor adjustments to one's working environment, possibly. But anything that gets into any kind of really heavy-duty discussion about federal law, state law, interactive process, accommodation, doctor's notes, undue hardship, regulations, city law interaction with that, sick leave, paid sick leave, family leave, pregnancy leave, baby bonding, you start getting into things like this, you're really asking for a very, very heavy duty legal opinion. So I think if you took it from some kind of, I don't know how you would define an ordinary day-to-day issue, but that would probably be where my comfort level for the employee's rights to be very carefully protected. Because the amount of, disability discrimination cases, I think, are the second largest number filed after wage and hour. So no matter how hard you try, and no matter how expert you are, HR professionals, everybody else, they get filed all the time, on those kinds of issues. You don't see too many lawsuits where somebody says, I wanted to leave 15 minutes early twice a week and they wouldn't let me. I mean, you do see that, sure, but that's not what you see. You see my doctor's note said I had this, your job description said that, we did a review of the interactive process, we didn't have the conversation, we did have the conversation, and it just gets to be too onerous. So from an ordinary day-to-day, relatively non-legal opinion type of situation, where you're not advising somebody's rights, but maybe an adjustment to the day, you could probably work something like that. But past that, I think you run into a lot of danger of an employee not getting the treatment and the care and the advice they need. I mean, the union setting, the union rep should be there. So I don't know how the paraprofessional fits in when there's already a person in that spot. I think that would be kind of strange to have another person there. And I think that would probably be something subject to collective bargaining anyway, if you were to start injecting that requirement into the grievance, process, progressive disciplinary process. That's probably, I don't know if you could do that arbitrarily by just saying this is what the new rule is, but that's where I think that's the best you could do, practically speaking.
Thank you. That's helpful to me, and I appreciate that. While you are, to me, it feels like you're giving a balanced response. But I can also see what you're saying, which is all those day-to-day minimal things could bubble up quickly and get complex quickly. So, I mean, maybe it's not even worth it. So, thank you.
Well, the comment that somebody else made was that the day-to-day thing sometimes isn't really what the problem is. That's not really what the issue at hand actually was. Erica or Dana said that. When you really drill into it, it's what's really happening here. Yeah, you couldn't leave 15 minutes early, but why is that? And then you have to get into, oh, well, I complained about the fact that there was this unsafe condition in the kitchen, or I complained about my coworker, or this and that. And then you start getting into all kinds of other things. I mean, if it's just as simple as we didn't have coverage, okay.
Right. Or the Caucasian people can leave early, but I can't, and I'm not.
Easy one too. Hopefully nobody's doing that anymore. But yes, if it's white people leave at 4, that would probably not be a great plan. So.
Okay, thank you.
Carolyn?
Okay, I have a quick question. I've worked mostly on the plaintiff side, and as everybody probably knows. So my question, hopefully this isn't totally unfair to you, but would employers be willing, you think, to pay a paraprofessional to help the employee? Would they, that's kind of a turnaround, I know, in your head, but.
So would they be willing to pay them? Well, I suppose the question would be, what do they get out of that arrangement? Number one, what does that do good for the employer? 2, I guess it would be how much. My gut reaction would be telling them that they have to negotiate with a third party who is trained or not trained or however else, and pay them for the privilege of doing so would probably be a very challenging sell, unless there was some benefit to that time and expenditure somehow as part of the arrangement by which this person would participate. But I mean, if you're talking about having a problem solved for $500 and not escalating into 5 years of FEHA litigation and hundreds of thousands of dollars burned and brain cells lost, then maybe the recommendation would be sure. I think what would happen is they would probably then say, well, the paraprofessional is here and says XYZ, and they have to call their lawyer anyway, which would probably cause them to be more likely to call. And maybe it gets this problem solved and maybe it doesn't. I don't know. It really depends, I think, on how it was presented and what they felt like they were getting from it.
Thank you.
Judge Yu, did you want to ask the question you have in the chat?
Oh,
You're muted, Erica.
Oh, sorry.
You just asked why would the employee trust someone paid for by the employer?
But Ira had his hand up.
Yeah.
Okay. Did you, Steve? Also?
No.
Oh, my thought was, Judge, Your Honor, just really quickly to explain my question.
It's rhetorical. Let's not use the experts' times. We can
talk later.
Yeah.
All right.
Question.
Okay, Ira, go ahead.
Well, I'm phrasing this in a kind of a loaded way, but I don't know how else to do it. Eric, if the paraprofessionals had the same training the union reps had, do you see any reason why they wouldn't be as helpful to the employee as the union rep is in the union situation now?
So assuming hypothetically they had the same training,
Yeah,
literally whatever the union rep school of union repping is,
yeah.
That's an interesting question because the union rep would be charged with the union, the employee and the union greater good, you know, the union's cause. And they would be looking at setting precedents and things that they are very fond of not doing. So if the paraprofessional cut a deal that was worse than the deal prior, I don't do a lot of traditional labor work. It's very specialized. It's a very different area. I prefer pleading paper and sitting around in court all day long. So the people who do the traditional stuff, you know, they're very big on precedents, never taking a step back, always moving forward, always getting more. And the paraprofessional would not necessarily be bound or wedded to those objectives, you know, or those ideas. Would the employee's interest be served the same if you had exactly the same training and you understood what the framework of the contract was and what the rights and duties were? Probably. But I don't think the union would go for that because I don't think that's consistent with the greater sort of, you know, what they're looking for organizationally across the board everywhere.
No, I agree. I'm talking about in the non-union shop.
Yeah, in the non-union shop, I think that you would probably have a better sell of having somebody with some training, trying to provide some advice and some guidance. I think it helps the employee make a better deal. And I think it also helps the HR people or the management people recognize that they're talking to somebody who has got more background, training, education as sponsored by the state bar, as licensed and approved by the state bar, than the employee who's upset and doesn't have any really, more likely than not, no foundation or idea what's reasonable or not, or what's right or not, or what's legal or not.
Thanks.
Any other subcommittee members? All right. Thank you, Eric. Abigail, thanks for your patience.
Oh, so I guess I'm sort of coming into this a little bit late, and I'm not sure exactly what the parameters are of the establishment of the paraprofessional program. But I, did prepare some thoughts about the program. And I guess before I begin, I just wanted to introduce myself. I'm an employment attorney. I've been practicing for 17 years. The first 10 were exclusively on behalf of workers. And then the last 7 has been on behalf of management and workers. So it's been a mix, and I've done wage and hour, wrongful term, harassment, discrimination, leave laws, etc. I'm the current president-elect of the Philippine American Bar Association. I'm a board member of the Asian Pacific American Bar Association. I'm the co-chair of the Solo and Small Firm Network of the National Filipino American Lawyers Association. And I'm also a commissioner on the inaugural Los Angeles Civil and Human Rights Commission. So my thoughts today, and again, I don't know what the current status is of the establishment of this program, but I had several thoughts on, why I am against licensing of paraprofessionals in the employment law context. So first, I think it would disservice immigrant and low-income communities, and it can open itself up to abuse and fraud. And speaking from firsthand experience, it was approximately 4.5 years ago. It wasn't on an employment matter. It was on a real estate matter that I worked with a colleague who, it was a couple from Mexico who owned a real property, who had paid like a notario, notary public service / accounting firm about $50,000 over a couple of years. The goal was to save their real property. They were out the $50,000, and after the end of it, also lost their home, which was market value at $700,000. You know, it was our opinion that if they had had an attorney, that wouldn't have happened. But again, they couldn't spot all the legal issues. This isn't in the employment law context, but again, you know, you have these low-income immigrant communities who are trusting people who are doing the unauthorized practice of law. And, you know, in this scenario, we're out, you know, probably around $750,000. Second reason is I believe that there are existing resources for immigrant and low-income communities to receive legal help from attorneys. We, you know, heard from somebody from Legal Aid at Work at BetSEDEC, but also in addition to those services, you know, I've been involved with multicultural bar organizations for a good number of years, and you know, one aspect of our mission statements is to provide services to our local communities, our local immigrant communities. And so whether or not these are through informal legal means, such as, you know, connecting local community members with attorneys through like, you know, like an informal referral network, or a formal means like legal clinics or know your rights seminars, those do exist. And, you know, firsthand, like I said, I'm on the board of the Philippine American Bar Association. Our board members provide pro bono services to local nonprofits that we informally partner up with, such as the Filipino Worker Center, the Filipino Migrant Center, Search to Involve Filipino Americans, serving, you know, the greater LA community. You know, as an aside, I don't know if this is the proper time, but, you know, one focus of the state bar, I think, should be encouraging more people of color to become attorneys, since often it's many of us who end up returning to our communities to provide this type of legal help. Third, it doesn't make sense to have paraprofessionals do the work that attorneys will do, quote unquote, for free. In other words, as a plaintiff's attorney, I don't charge for the legal services. It is done on a contingency fee basis. The worker doesn't have to pay costs up front. They don't pay any fees up front. These are for wage and hour issues, harassment, wrongful term, disability, etc. So why would you have a worker pay a paraprofessional when, you know, they could get these services for free from an attorney? Fourth, as a practicing employment law attorney, you know, employment law matters are very complex. You know, California, I think, is the most protective state in the union, and the laws are always changing. You know, in the past 7 years, when I expanded my practice to also counsel management side and employers, I've dealt with a lot of professionals in human resources. A lot of these individuals have been doing this for, you know, 20 plus years. They have certifications from well-known HR groups like SHRM, and despite their numerous years of practice out in the field, they still need the guidance of an employment attorney to navigate through the complexities of employment law, you know, the interplay between California law and federal law, the new laws that come out, you know, every January and July, and sometimes in between, especially now with coronavirus. I feel like every day I have to look at the DOL website. You know, and finally, in representing many employees over the years, you know, employers often ignore direct demands made by their current and former employees. It's usually not until you have the threat of potential litigation or arbitration that employers will perk up and do something. And, you know, even with litigation looming over their heads, some employers still ignore their employees' demands. Therefore, I think you need an attorney to enforce workers' rights in order for the employer to do the right thing, or to, you know, pay up in the case of damages. So I think having a paraprofessional who's unable to file suit or basically go, you know, the whole way could be hurtful to an employee's future case. And, you know, just the last point, it sort of presents itself like a David and Goliath. When I represent employees, you're already in a position where you are a small law firm against, you know, big multinational companies, or even, you know, like 1,000 attorneys against 2 to 5 attorneys. Already presents itself like a David and Goliath position. I think having paraprofessionals represent employees would further exacerbate that. Those are my points.
Thank you. Okay, go ahead, Eric.
I just wanted to say that the idea of this payment thing that was brought up, I think somebody brought that up. If the employee is never going to pay for it because they don't have any money to pay anything to anybody to represent them, that's just not going to happen. And the employer paying for it's probably not really likely or feasible unless they get something really positive out of it. So it has to be paid for by somebody else. And whatever that ends up being or not being, it seems like that's, you know, if you're going to, it's going to be some low amount of money probably, which is weird. But this idea about the notarios and everything, because I was thinking about that with the abuse that people find themselves in the underrepresented communities. I think that is a very valid question. But in this context, though, it's, you have an employee, you have the employer, and then you have the paraprofessional. So there's another person in the middle of it where you're not having somebody preying directly on the individual. You have somebody in the middle of it. And I think the abuse angle of that might be mitigated by the fact that there is that, or you could find out that they would be happy to let them get abused. But it seems like that the existence of HR or management would prevent the paraprofessional from doing something that would be considered to be abusive or fraudulent or grossly negligent, you would hope. So I think that's a little distinguishing. The other random thought that I just had is, if the paraprofessional interviews the employee and they spend 5 hours talking about everything, if you had a lawyer, that's completely privileged and you never get to know what happened there about whatever it is they did or didn't say. But what happens if it's the paraprofessional? Is there gonna be a privilege attached to that, where that conversation is effectively legal advice? Because it seems to me that then you get into a whole different discussion of discoverability. The paraprofessional is now a witness at trial or arbitration, you know, and do we have to subpoena them? Who do they, you know, who is their employer? It just seems like, you know, there's all kinds of other issues, which I'm sure you guys have talked about, you know, malpractice insurance and, you know, negligence and all those things. But it seems like that there's so many different, and I agree with Abigail. I think that, you know, and I'm only an employer side guy. So that's my lens totally. But I really think that the number of things that could go wrong for the employee is far greater than the employer, I think, would be better served by this far and away than the employee would. And I don't think that's the point of what you're trying to do is, you know, give anything, you know, help. I think the employee is what you were supposed to be looking at to protect them better than they were without anybody there. But I think that this idea in the employment context just has way more negative pitfalls than it would otherwise.
Yeah, if I can just respond to Eric real quick. The potential for abuse will likely not be quite as great as the real life example that I had, but for a low wage worker who's making minimum wage and has to pay a paraprofessional $2,000 for doing nothing or giving them bad advice, you know, that could be rent for that month, and that means homelessness perhaps. So I think it can be great, even though the real dollars aren't that large. And then just to address Judge Yu's question, I don't know if all counties have active minority bar associations, but I know, for example, in Northern California, we have sister bar organizations, API and Filipino American, which I'm involved with, and they do have active legal clinics and pro bono services. Definitely in the San Francisco, Oakland area.
Yes, thank you. I agree. And I was the president of our local Asian bar, but I'm thinking, you know, the smaller counties, I'm not sure, like Trinity or those kind of counties.
The state bar does have that information, and it's very much concentrated in urban, suburban areas. There's not widespread availability throughout the state. And they don't all do the same thing. Did any other? Yep, okay. Carolyn.
Okay, so Abigail, you spoke about returning to the community and how attorneys from diverse backgrounds tend to go back to their communities and provide services there. How does that relate in the employment context, and does that overlap with immigration?
I think not all attorneys will necessarily go into like employment law or immigration law like I've done. But what, you know, I've seen from firsthand experience in working with minority bar associations is that even big law attorneys of color will provide pro bono services back to the community. I don't know if that exactly answers your question though.
Yeah, kind of. Let me just ask a different question. We think of, and you mentioned notarios, we tend to think of, I think in our public consciousness, notarios and Latino, low-income Latino workers and families. Can you speak to other immigrant communities, other diverse communities, such as the Filipino community in Los Angeles, I know is huge. Is there a notarial kind of thing that goes into those communities that we should be concerned about or think about?
Yeah, it's sort of similar. You know, they're like accounting firms or anything adjacent to sort of the law. So it's like either accounting or notary services. And I don't think it's quite as prevalent in the Filipino American community as it is in Spanish speaking communities. And just because a lot of Filipino Americans can actually speak English, and so they can seek services from a lot of different types of groups, such as like Vet or legal aid, even if they don't speak Tagalog.
Okay, and then I asked, I think, some of the other panelists about this. What do you think about the overlap? Kind of blurred questions there. Sorry about that. That's the first one. What do you think about the overlap between asking for reasonable accommodations, having to deal with workplace grievances, and immigration?
I'm sorry, what do you mean exactly? What do you?
Well, if low-wage employees have problems with those two areas, and actually what we're dealing with here today is we're talking about a couple of narrow issues and whether those will move forward for further consideration on all those procedural kinds of questions. So we're just kind of going through these last couple of meetings. Is this issue a good idea? Is that a good fit? Is this the appropriate way to go? And we've been talking about reasonable accommodations as something a paraprofessional might be able to be involved in, and workplace grievances, those two specific areas. So my concern is that if a low-income worker or worker, even middle class, the concern is that they won't have the power to go in and negotiate. But if someone has immigration issues on top of that, is a paraprofessional going to be able to deal with the combination of threats of immigration actions and immigration problems that will be, you know, that could complicate having someone who's not an attorney and especially a certified immigration specialist working with them?
Yeah, I mean, I think I think this was mentioned already before, but you know, workplace grievance is it's such a broad term, and it can really encompass anything. You know, most employees that I talk to, and I think somebody was saying like out of 100 employees, that I talk to, maybe 10 have an actual legal grievance, and it requires an attorney to flag that issue. You know, many employees have grievances, and whether or not that gives rise to a legal claim, I think really requires the eye of an attorney who practices employment law to be able to flag that. My worry on the interplay with immigration is something that Eric sort of brought up, is that there's what about privilege issues? If a worker comes to me and, you know, tells me that I don't have any papers, that's privileged. And I know that California still protects undocumented workers in the employment law context under the labor code. And, you know, my fear would be that that information, you know, wouldn't be privileged if you have a paraprofessional giving guidance to the employee.
Ira?
First, I want to say I certainly would advocate when we get down the line here in our working group that the attorney-client and work product apply to the paraprofessionals. And we can recommend that in our group and other statutory changes. Anyway, but you made a point that 1 out of 10 people, that caught my attention, 1 out of 10 who calls with a grievance, which could be, you know, any complaint they have, only 1 out of 10 has a real potential legal claim. You know, for instance, people think a hostile workplace, saying, oh, I got a legal claim, but usually not. But how about the 9 out of 10? Those and they have the interactive process to deal with at work, or they have a grievance of some sort that's not a legal claim. Assuming that you wouldn't represent them, and assuming they can't get representation for that because it isn't a legal claim, don't you think it would be better for them to have some help by a paraprofessional rather than no help at all, going in there alone?
So, I mean, my thought on that is if it's not a legal claim, then likely the damages are going to be low. And you know, the point of this, right, is to service underserved communities or low income communities, so likely minimum wage workers. And so why would it benefit them to pay even $1,000 to, you know, for someone to talk to their boss to get them out of work 15 minutes early a day?
Do you think it would benefit them if they could get it for free or for $50?
But I guess the point is, so maybe 9 out of 10 don't have a legal issue, but what about that 1 out of 10 that does have a legal issue and has, you know, various violations? The paraprofessional may not be able to flag that. So what happens to that one?
You know, if it's the interactive process or a grievance, well, I agree with they got to be sufficiently trained so they can flag issues. You're right.
Yeah, I have a question.
Okay, and then I suggest we move on to public comment, but go ahead, Carolyn.
Oh, sure. I totally forgot we didn't do that first today. Okay, one last thing. What about, and we talk about individual rights and that sort of thing, one person at a time, but could you just briefly give us a mention of PAGA and what a paraprofessional could do to the ability of a class, low-income workers or even middle-income workers as a class to bring a claim? How would settling one be a problem of hurting all?
Carolyn, didn't we vote PAGA out already?
Well, we have workplace grievance in, and I guess we maybe should talk about redefining that and maybe bring some people back.
I mean,
we did
vote. The PAGA is to be able to file it in court, and you know, part of getting it resolved is like the attorney's fees provision, because there's a clause in PAGA that allows a judge to reduce it to something quote unquote reasonable. And while, you know, plaintiff's attorneys can say something's $1 million, it's always the defense attorney who says, well, sure, but the judge could always say it's 25,000. But you know what is in there that puts the pressure in PAGA is, fine, let's litigate it, and $500,000 in attorney's fees later, you know, it's $50,000, but it's still 500 to you. So then there's that negotiation and back and forth to come up with a settlement of, you know, 300,000. So I don't know what the pressure point would be for the paraprofessional to pursue PAGA.
Right.
Right,
It kind of answers my question.
But if you're saying, could a paraprofessional be trained to understand how to timely and correctly file an LWDA letter? Just to
If
get
it was necessary, right, if that was the right thing to do for, like, one person walks in and says, I have this issue.
So if you were talking about just doing, you know, filing a DFEH charge, which is basically on the website, you know, click on the forms, click on the boxes, fill it out. That's one thing. If you're talking about an LWDA where we end up with exhaustion arguments and, you know, timeliness, is that something that's so far out of the realm to train somebody to say, this is when you have to do it and this is the things you need to put in there? Probably not. But then again, after that, once you step into court, they shouldn't have anything to do with it at all. And even the filing of the charge, I think, you know, because of the requirements, you know, and if they did it wrong, you're talking about a potential impact on a class of people that could limit significant amount of recovery for the state and the aggrieved people if they just, you know, forgot to put something in or missed some paragraph or did it 3 days late, whatever. In theory, is it that hard? No, but if I saw it by a paraprofessional, I would be going through it even more laser focused than ordinary to see what they didn't do and what they didn't forget, and every argument I could make where it wasn't fleshed out right. You know, I think, and I think dealing with one person is one thing, but when you're talking about a class or representative action, and you've got, you know, potentially hundreds of people who could have their rights impacted by that person, that seems like a really sketchy idea to me. I would not be super comfortable with that.
One last point, and once that LWDA notice is filed, you only have approximately 120 days to add the PAGA claim as a matter of right. So then the clock starts ticking. You would need an attorney anyway, pretty soon.
I see your hand up, but we really should get to public comment because it's 6:10.
Make one sentence.
Okay.
It's really one sentence.
Okay.
I don't see any possibility that a paraprofessional who doesn't catch all the causes of action in a PAGA letter, LWDA letter, will blow any causes of action for a class. I don't think it's possible the way the procedures of that work. I could explain, but I won't. No.
Let's move to public comment. Thank you, Eric and Abigail. Members of the public, I see many of you. All right, I see Tony Jaramila.
I'm going to go ahead and promote.
Okay, great.
You're on mute, Tony.
Okay. We're going to keep pretty strictly to 2 minutes of public comment.
Oh gosh, okay. Well, thank you for giving me the opportunity to share my perspective, and I'm sharing it as someone who grew up in a working class immigrant community. My parents and I were from and my large extended family are immigrated from the Philippines. And I'm also a past chair of the Philippine American Bar Association. I've been practicing employment law for over 25 years, past chair of the California Employment Lawyers Association, chair of Foundation of Advocacy, Inclusion, and Resources, which is a nonprofit organization that's mission is to promote cultural and gender diversity. And I was the past chair of the State Bar Labor and Employment Section. And I say this to just give you context and to let you know that I'm speaking as someone with boots to the ground from the community and working in the community, and had, you know, if the goal to address the justice gap is to make legal services more affordable and accessible to the immigrant communities and the low-income communities, had the working group asked us, the people from the community, we would say that this would not be the solution, is in having a paraprofessional program provide legal services to our communities. And as what Abigail was saying, and just kind of to echo that, there are multicultural bar organizations, ones that I've worked with and continue to work with, who provide these type of legal services free to underserved communities. And there's, as well as these legal services communities, organizations that are providing, you know, like Betsedic and Legal Aid, who are providing these free services. So I think that the solution with regards to the justice gap is not to have a paraprofessional program, but rather to support the existing programs like the bar organizations and the legal services organizations. And then just to kind of address some of the questions.
Tony, I'm sorry, I just, it's been 2 minutes and our meeting ends in 17 minutes. So I'm gonna see if there's any other public comment. If there's not, I can give you 2 more minutes. Anybody else I see in the attendee room? No?
I don't see any raised hands, Leah.
Okay, all right. So why don't you take another 2 minutes?
Okay, so then I'm going to just jump to the point that I wanted to be very, very clear, and this is based on my experience doing employment law, that I don't believe that there is any aspect of employment law that should be handled by a paraprofessional. Any kind of issue that comes up, even grievances that come up in the workplace that may or may not be a result in a legal action ultimately, the problem is that you need a trained attorney, an employment attorney, someone who is trained and licensed to be able to spot those potential issues. And you can't I don't see any possibility of being able to carve out, for example, okay, it's only going to be the interactive process or a accommodation issue that a paraprofessional is going to address and handle, because that is going to bleed into other areas of law and other, you know, what if this accommodation issue is not being provided because of some, you know, retaliatory adverse action that resulted because of a protected, because of protected activity. What if the reasons for this grievance and the issue at hand is because of discrimination? So there is just not, in my point of view, and just in practicing this area of law and being, you know, in litigation, in trial, and doing advisory services to clients, I just don't see that there's any kind of, if there's any aspect of employment law that could be handled by a paraprofessional.
Okay, thank you. Anybody else for public comment?
I don't see any raised hands. Oh, I do see one from Jean Harrison. I'm going to go ahead and promote
Okay,
him.
thank you. Hi, Jeannie.
Hello, thank you for having me. Just a couple of points. Again, I'm the president-elect of Consumer Attorneys Association of Los Angeles, CAWA, the largest local plaintiffs bar association in the country, and have been doing employment law for going on 28 years. I have many times, actually, I think Eric and I know each other. Hello, how are you? From being on the other side of the V from one another. And I will say that I have a number of times tried to participate in the interactive process directly, participate in some investigations with employers. Employers routinely disallow that. They do not want lawyers or outside personnel, as Eric mentioned, to participate in these processes. So I do not think it is realistic at all to expect that a paraprofessional is going to be able to somehow insert into the process of communicating with the employer. Even I'm not able to do that successfully in the vast majority of circumstances. Also, the next point is when would a paraprofessional get involved? Because what happens is the employee goes to HR directly and says, I have this issue, I have that issue, if it's reasonable accommodation or interactive process, and says, I need this time off, I have this doctor's note. It is HR's responsibility under the law to engage in an interactive process in a fact-specific and thorough discussion, whilst also respecting the privacy interests of the client, of the employee at that time, and not to unduly delay. So who is it that's going to be saying to the employee who's having a medical issue at the time or a need, you know, oh, stop talking to us, we're HR, you need to go out and find somebody to hire on an hourly basis to get involved in communicating with us. It's not realistic. I don't think it's consistent with the employer's interactive process and reasonable accommodation obligations. And employers are not going to allow us to insert people into those processes. Again, also, I want to emphasize the point that I think from my observation of these and participation in these hearings, and thank you very much for having us participate, is that I want to be very clear that as contingency lawyers, when a potential client with a reasonable accommodation interactive process comes to me, I do not say to them, open your pocketbook, you'll need to give me a retainer, and my hourly rate is whatever it is. I say to them, let's thoroughly discuss this in a confidential and privileged setting, and I will advise you about how you should be communicating with your employer, and you can call me and we'll work through this together with the goal of making sure that you get the accommodation. If it turns into a case, it turns into a case. If it doesn't, it doesn't. But I do not charge people for that, and I don't know a single other plaintiff's lawyer who does. So again, we're talking about going out there and creating an expense obligation for employees who do not have them currently. And that is a burden.
If you could wrap up your comments.
Yes, thank you very much. And then on the exhaustion issues, and DFEH or the LWDA letters, I can tell you that it is routine in any case with any case that's brought, is that those exhaustion issues are thoroughly vetted by the defense, and they will be bringing, for example, a motion for summary judgment based on the failure to click the right boxes, based on the failure to put in the right names, et cetera, et cetera. Everything that can be done to fight a case as a result of an alleged failure to exhaust properly will be done, and cases have been reversed. A case I tried when I took over the case after prior counsel, after discovery was closed, I got a giant verdict, and it was reversed by the Court of Appeal based on prior counsel's failure properly to exhaust the administrative remedies. Thank you very much for listening.
Leah,
Thank you.
can I ask Ms. Harrison a question?
Yes. Go ahead, Steve.
Ms. Harrison.
You're frozen. Yeah.
I'm Steve Fleischman. I'm a partner at Horvitz and Levy in Los Angeles. Thank you for coming today. Our committee has decided already that if the interactive process fails and you end up in Superior Court or federal court litigation, that cannot be done by a paraprofessional. It has to be done by an attorney. So there's going to need to be a handoff. And my concern is, however many rules you have against fee splitting and however many rules you have against runners and cappers, there's going to be pressure to give referral fees, to split fees with paraprofessionals who refer cases to plaintiff contingency attorneys. And so my question for you is, I understand you personally have a high-end practice and that may not be a concern for you personally, but in your capacity as representing the consumer attorneys, are you worried about the pressure being put on sole practitioners who want to comply with the law, but it just seems to me, you know, the way the world works, there's going to be a lot of pressure on them to play ball directly, indirectly, under the table, whatever. Tell me I'm right, tell me I'm wrong, just give me your opinion.
Thank you. That is definitely the case. That is something that we are constantly addressing in CALA, and it's something that we're very concerned about. I believe that many of us in CALA actually have submitted letters last fall addressing that very concern. And so the challenge is that there are unscrupulous people who, even now, who are not lawyers, who are just, you know, fixtures in the community. And what they do is they go out and they basically find out about potential cases, and then they come to lawyers. I've had them come to me, right? I mean, not at my request, but people have come to me who are non-lawyers, but are connected community members, and said to me, if I send you cases, will you pay me a referral fee? And my answer is obviously not. That's illegal. And I literally, like, I would never do that, right? But you are creating another business opportunity for people who will do those things. And it is a big problem.
Ms. Harrison, thank you very much.
Thank you.
Ira. Ira.
Got this other shut off. It's already going on. I've been approached too by more than one for a share of a class action even. But this occurs to me. If the paraprofessionals would be licensed, they would be under hopefully the same ethics rules and discipline and possibility of losing their license as lawyers. That's what I advocate anyway. So doesn't it occurs to me that makes it a new class of people who, yeah, could ask for an illegal referral fee, but are way less likely to than an unregulated person, and may take some of the nasty solicitors of illegal fees, might take some of their business. You think that's right, or you think it's wrong?
Well, first of all, I've had people who are paralegals currently come to me with that proposition. Okay. So I don't know what the difference is going to be between this paraprofessional program versus the existing paralegal program, which does have, you know, supervision. I mean, it's under the Business and Professions Code and does have supervision by lawyers and that kind of thing. And so, and those people do have certificates and they have gone to school. So I really, no, I think that it is another business opportunity, and they are absolutely going to prey on the, you know, immigrant and low-wage communities who deserve more good legal representation, not more poor representation.
Okay. So it is about 6:25. Thank you, Jeannie. We've got 5 minutes left in the meeting. I'd like to be responsive to the information requests that we've had. So Linda, if you could very quickly put up on the screen, and I believe this is in the Dropbox, the details from the Justice Gap study on employment. Let's get past wage and hour. Let's focus on the two we're talking about today. This was the detail you all had requested about those who do not seek legal help and the reasons why. So we have denial of workplace accommodations here. And basically how you read these, you all have access to them. The blue bars are those above 125% of poverty. They're red below. And I do want to clarify for everyone, we've heard a lot about low income, vulnerable populations. And of course, it's a really important population. The paraprofessional program, however, is most likely would be addressing the group of folks that would not qualify for legal aid services above that 125% of poverty. So you can see here reasons why people don't seek legal help. Not sure if it's a legal issue, worried about the cost, where you can see you have 0% above 125% of poverty for denial of workplace accommodations, and the various reasons here listed.
Leah?
Yes.
Could I just clarify?
Mm-hmm.
So I understand from the Justice Gap report that 68% of people do not seek help. And I understand what you're saying is these charts represent that 68%. Do I have that right?
They represent the people that do not seek legal help.
Okay. My question was actually about the 32% who do, and do they have trouble finding lawyers to help them? Am I correct in assuming that the Justice Gap study doesn't address the 32% and the why?
It does. It breaks down how legal help was received. And I think a point Linda's made previously is that, and we got a little bit of that with the Beth Sadek woman, that they would provide some kind of on-phone response. That is counted as legal help in the Justice Gap study. So we have done these charts. Now we'll do others that reflect those that did get legal help. What types of legal help did they receive?
Okay, as long as we'll get that next time, you've answered my question. Thank you.
Absolutely. Ira.
I also understood that was Steve's question.
Okay.
Sorry. No, that's all right. It's, I just said that because I tried to address it myself. I sent this memorandum, which is 90% quotations from the Justice Gap study, that I think shows what happens to the 30, whatever it is, percent, 42, not 32, who, or whatever it is.
32.
32, is it 68 that don't?
68% make no attempt to find legal help.
Okay, 32, right. Anyway, it's what I could find in the Justice Gap report that shows what happens to those people. And I think it shows that there's still a big justice gap for those people, inability to find legal help.
So we will create the right
I had a
chart.
question too. I had a couple questions.
Mm-hmm.
Okay.
Yeah.
First of all, this is not, and I think I sent it to you, Leah and Linda, in an email. And I guess we're not supposed to email each other, so I don't know how we're gonna communicate. but I sent you guys an email saying this was not the information that I wanted. There was some specific information and some charts and tables in the Justice Gap study that were not backed up that I could find. And you pointed me to the raw data. And in that raw data, they have 1, 2, 3, 4, 5 questions. So this is broken down into a binary 2, yes or no. 1 for the, there's no numbers here. There's no discussion of when it says people did not seek help. There's a real problem I have with the way these tables look compared to the actual way the questions were asked. And I don't understand.
So Carolyn,
that's the one thing. And I understand that you're going to get me involved with NORAC, and we're going to maybe see if we can work through and find the actual underlying data, because I don't know where these particular answers came from. They're not anywhere that I can find. The other thing is, if you go to page 1 of this, and thank you for sending these to us in advance. If you go to page 1, I'm really troubled by the fact that there's a list on there that includes categories we've already decided and excluded. And I don't want any of this to sneak back in saying that, oh, well, it was in there on the date and you guys didn't bring it up. So if you could actually have Linda flip to page 1 of this.
Oh.
Okay, there was
I didn't include the cover page, but what's included here were this wage and hour claims, if I can flip through, workers' compensation.
Yeah, workers' comp is out.
Yes.
Oh, right. I apologize. That was an error on my part.
There's 7 pages though. We have 2 issues here, and you've got 7 pages. So there's
well,
no
some of the pages have to do with the bar exam information that was requested. So it's not all from the Justice Gap study. But workers' compensation was included inadvertently. I apologize for that.
Okay, let's go forward to the bar exam data. Again, you all have this. We'll get the right charts out to you for the next meeting. This information was requested, the impact of the reduced cut score. You can see here over the last 10 administrations of the exam, had the cut score been reduced to 1390, you'd have about 6,200 more lawyers in the licensed attorneys in the system than you do now.
But let me clarify it. Actually, the number is lower than this because this is the number of exam takers, and it could be that some people are counted more than once. So if someone had gotten that higher score at an earlier exam, they wouldn't have taken it later.
Question.
Mm-hmm.
Putting aside the lower bar exam, year over year, I understand there are more attorneys in California. In other words, there are more passing the bar, joining the bar than are retiring, dying, etc. Is that correct?
It hasn't been correct. It wasn't correct during the period we had very significant law school enrollment declines. I don't know the current status, but that's another piece of data we can get.
If you could look into that, I'd appreciate it. And then I only saw one place in the Justice Gap study where it talked about how many attorneys are needed to close the justice gap. And it was limited to low income.
Yeah, you can advance the slide, Linda. It's here.
8,961. There we go. So, you know, eyeballing it, it looked like 1,000, 1,200 new attorneys a year. It looks like that's going to, that problem may solve itself in a few years.
Well, that does assume that all of 100% of these attorneys go into legal aid work. This is the justice gap for the legal.
This is low income.
Yeah, it assumes that all new attorneys will choose to do that work. Ira, and then I want to move on to talking about our next meetings. I'm sorry, we're already over. Go ahead, Ira.
That's right. It assumes that all these attorneys are going to go into helping low-income people, and that's way far from the truth. I doubt that 1/10 of lawyers of new lawyers go into that, particularly because of how much it costs to go to law school, and they have this big debt. Oh, except at my school.
Okay. So I apologize for keeping everyone over. I did want to talk a little bit about how we want to communicate with one another. I asked Brady to stay on just to give us a quick reminder on the Bagley-Keene rules. I also want a reminder about civility and the fact that all of our emails are public records. So I want to encourage that we remember that. And maybe after we hear from Brady, we can talk about the next meeting. And I'd like to ask you to think about limiting our number of presenters because it's becoming really challenging with the presenters and public comment to give you any time for deliberation. So Brady, if you could quickly remind us of the rules around intermeeting communication.
Sure. The key to remember is that we need to avoid having a majority of the members of this group communicating with each other outside of a noticed meeting like this one, a publicly available noticed meeting. I sent out a reminder of that. There were some group emails that bounced around, and I got a question about the specific law. And if anybody wants to look it up, it's Government Code Section 11122.5B1, and that talks about that a majority of the members of a state body such as this shall not, outside of an open meeting authorized by Bagley-Keene, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that's within the subject matter of the body. And the way that comes up in emails is that if one person sends an email, that might not be a series, but if anybody in the group who receives that email talks to another person about it, responds to it, forwards it, that right there becomes a Bagley-Keene violation. So we ask that you not do that. If you have anything to forward to the group, that can go to staff, and then staff can send a one-way email out. We will try our best. We're asking for a violation if we don't use the BCC field, because you might hit reply all and then a violation happens that way. But just the safest approach to keep us in compliance is not to communicate with each other by email, and to direct everything through staff.
Thank you. Ira?
Brady, you said not to communicate with each other by email, go through, but it's okay to communicate with one person by email, isn't it, or no?
I mean, so our best practice and what we always advise is not to, because the minute, number one, it sort of violates the spirit of the act, which is our discussion should be happening open. But if you have a discussion with one person, he might repeat what you say to another person, and that becomes a series of communications amongst a majority that violates the law. So yes, you're right. A one-on-one communication conversation would not in and of itself be a violation, but you don't have any control, and it's just human nature to repeat what people say, to call somebody else, get their opinion. We want to avoid that.
They should change the law and just say any two people.
Right.
Okay. So thoughts about the next meeting. My suggestion that we limit presenters. I'm not sure you all feel like we need to have any additional presenters, but would love to hear what you all would like to do at the next meeting.
I think we need to start taking some votes.
I raised my hand, Steve.
I'm sorry.
That's okay. Thanks, Steve. So I feel that we have been saturated with a lot of public comment and the people are really coming from a position that is singular. And to me, it was helpful to hear from the subject matter experts, especially, and I'm just going to say Eric because I'm an Erica and I don't want to mispronounce your last name. But I mean, I feel like when people are balanced and can sort of see both sides, despite what their practice background is, that's the most helpful thing for me. But hearing someone tell me stories about their own particular cases is not so helpful. And then when people ask questions of the public commenters, it's like, it's all cumulative. And I want to have somebody make an objection that I can rule on and say, cumulative, let's move on. So I'm not finding it that helpful, and it's consuming our time and we don't have time to talk. I think we do need to have a conversation, but it is past 6:30, about how we communicate with one another. And I did send an email, which I hope is okay, because I know of the Bagley King issues, and I'm so sorry, Brady, but I just felt that we needed to have a reminder that we are colleagues. We are going to be colleagues on this for over a year or maybe a couple of years. And our relationships with each other are the most important thing for us to get a good work product and work on this together. You know, it would be so much easier if we could meet in person, because then there's some collegiality, and I always bring chocolate to every meeting. And, you know, I think hopefully that helps with some stress and collegiality, but that's not possible. These are extraordinary times, and I think we have to dig deep in ourselves and pull out the best of ourselves so that we can meet the challenge during these extraordinary times. I know Leah would like to discuss this. I would like to have her do that, but I'm not sure if people can stay late. I'm willing to stay and have us have that discussion because I think it's important.
And I thank you, Judge Yu. I don't know how much discussion we need to have. I think Judge Yu said it very eloquently. I would hope you all agree to what she said. I feel, as I've shared with some of you, that you're all working incredibly hard. This is a lot of hours. Look at the time right now that you're spending your volunteering. And I really hope that we all feel we're coming to this work with the best of intention. And that goes for us as staff. So when we mess up, like today, we made the completely wrong slides, please, you know, give us a little slack, because we are really trying hard and there's a lot we're trying to manage. So I think if we can be gracious with one another, assume the best of intentions, be really mindful of the words we use, that's the best we can hope for. I don't know how much more discussion we have to have about it. Carolyn.
Yeah, I had three experts that were we tried to get in today, but we had one that repeated, And so I don't know who invited that one to repeat. She was great, terrific person. But I do have, there's a lot of lack of experience in employment issues in this group. No offense to anybody, but the labor grievances, specifically the union labor grievances, were only touched on by someone who said they weren't an expert in that. I have two people who are experts on both sides, one union representative, one non-union representative, to come and talk to those specific issues, which I think very clearly, and I've said from the beginning, do not belong in this conversation. So I really think we at least need those two things. But I also would like to hear somebody more specifically talk about the medical issues and bring people in. I really think that when we start these meetings, we need to give people, you know, the direct instruction that we've been given, which is two separate areas, and then really focus their discussions. I know Judge Yu wanted to hear about people from communities that were served with non-English speaking, and I hope I have brought witnesses that satisfied and addressed some of her concerns. But I did have witnesses that would talk to some very specific things that I hope we can still hear. And if we don't have time, then I don't think we should rush this. If we get to 8:25 and we don't have a report, I mean, if there's no draft report until 3 days before the meeting, as we've done before, I don't know how we can evaluate it with all this technical information that's been given us. And I think we need more technical information. Maybe it's my biochem patent law background. I'm a picky, detail-oriented person. But I really at least need those two people, and unless we can vote right now and get rid of the specific labor contract grievances, which, yeah, I can't even fathom why we're discussing something that has to do with contract bargaining. But
okay, so Carolyn, what I'm hearing from you is not a response on the communication agreements, but I'm going to assume that means you're in agreement with some of the statements that have been made, and that you would like to have two additional speakers at our next meeting. That's
at least I had two others. I don't know how we can, you know, maybe we limit their time, but these are employment is ridiculously technical.
Okay, Stephen, you had your hand up.
Yeah, I agree with Erica that we have been inundated with information. My view is I think we should focus the next meeting on airing out the issues, taking some votes. If we are deadlocked 2-2 on the remaining issues, then this subcommittee is going to have a longer life than any of us thought, and then we can bring in the witnesses that Carolyn wants. I have some witnesses I'd like to bring in on some issues. But, you know, Erica, you said at the very end of the last meeting, you were inclined to vote one off, and if we come back next week and you can vote one of the two off, then we reduced our issues by half. And if we come to agreement on the other one, we can save a lot of time. So I agree with Carolyn. My only disagreement with Carolyn as to more witnesses is timing. Let's have a meaningful discussion among the committee, and if things survive, then we need to have more witnesses. I agree. And if something's voted off the island, then it's voted off the island, and we don't need witnesses on that.
Just as long as we don't vote Eric off the island, he looks very comfortable on the island.
Judge Yu and Ira, are you okay?
Eric is one of my best friends. He is always comfortable, let me tell you.
Judge Yu and Ira, are you okay with that approach for the next meeting? No presenters, we'll just have a discussion about these two issues.
I've been working with people. These are very
Sorry,
people.
she asked Judge Yu and Ira. So can we please respond, Carolyn? Go ahead, Ira. I have been putting comments in the chat.
All right.
Go ahead, Ira. Is that okay?
Yeah, I'm okay with that. And to make it a little easier, I agree that that there's no place for these paraprofessionals in the union situation. The union is supposed to be the sole representative of the employee, unless they're suing about something that's exempted from that law.
Okay. And Judge Yu, it looks like you invited DeCarroll. So are you okay with maybe changing that approach just for the next meeting, or We can ask her questions via email.
Oh, I'm saying I invited to Carol back this time and because Carolyn was complaining about a repeat, and it was because I didn't get an answer last time. And Ms. Davis wasn't going to be able to come back, but she graciously came just to answer that question. So I'm fine with the approach that Steve suggested.
Okay. So Carolyn?
The two attorneys that I'm trying to get scheduled are extremely busy. So I tell them to, these are union labor people. And so if we could, I need to know what to tell them.
I think what we're saying is not for the next meeting. The next meeting, we're going to give you all time to really just have a discussion, and then that will inform next steps. And maybe some issues will come off the table, and that will inform next steps.
Okay.
Thank you all, and we'll get you all the corrected charges.
Sorry, I wanted to just make sure everybody felt that we had the contract, our social contract in place about how we're going to communicate with each other. Did anyone want to say anything?
I think strict compliance with Bagley-Keene will solve the problem. Okay. The problem will solve itself.
All right. Thanks.
Yeah,
thank you.
Of course, Your Honor. No, I stayed out of those emails.
So Leah and Brady and Linda, you have been, and Greg, I don't really know you, Greg, and I'm not sure what your role is, but I know Leah and Linda have been working all hours and really have done an extraordinary job. We have been a very demanding group and not always as gracious and polite and grateful as we could be. So thank you, Leah, and thank you, Linda, for all the efforts. I know you're doing this multiplied by 20 or 12 groups, so thank you.
Thank you, and Greg is a very important person. You should introduce yourself.
I just want to thank you all for letting me lurk in your meetings here. I came in after your first meeting. I am your Supreme Court liaison. I'm a lead attorney for the Supreme Court, and I've filled this role in many working groups in the past, and I admire the work that you're trying to do. It's a huge undertaking, and I would probably just underscore what Steve said. The more issues you can get off the table quickly, the more streamlined this whole process will be for you. Just from past experience of being in these working groups with a lot of different ideas, certainly if you can vote off the whole union, non-union representation aspect of the paraprofessional program, we don't need to hear from those witnesses, I would think. So,
and Araya still.
Greg, now.
Thank you, Araya.
All right.
Greg, now that I know your position, is it unfair to ask you when the governor is going to fill Ming Chin's position?
Well, if you find out, you can let me know.
Okay.
All right.
Thank
you all. Have a good evening.
Bye.
Good night.
Thank you.